Hey, everybody, this is Advocate Lucinda, your empowerment lawyer. You know, discovery is critical, and those of you who have litigated by now, you know that's true. Without discovery, without gathering information, you cannot make your case. It's just a fact. And the way we customarily obtain our information to help us make our case is through admissions, filing interrogatories, production of documents, depositions, and even subpoenas. But there is a tool through which we can gather information that we don't often think about. And that is the Freedom of Information Act. Let me ask the question. How many of you have attempted to obtain information through the Freedom of Information Act? But today I want to talk about the prosecutor withholding evidence. This video will demonstrate how a defendant can attack their conviction or sentence as unconstitutional or contrary to federal law. As it relates to the prosecutor withholding information that could have proven the defendant's innocence at trial or at the 2255 hearing. We're going to be looking at an actual case where the appellate court remanded a Section 2255 case back to the district court to review and determine whether the defendant's allegations that the prosecutor committed fraud by withholding evidence that the defendants requested through FOIA. So let's get started. And the case we're going to look at is Henry William Leonard Pickard, Henry Clyde Apperson. In 2003, defendants were convicted of manufacturing LSD and possession with the intent to distribute. Defendants appealed their conviction. The appellate court affirmed the district court's ruling. Next, defendants filed motions for relief under 28 U.S.C. 2255 to set aside their conviction and sentences. They alleged the prosecution had violated their rights under Brady and Giglio by suppressing impeachment and exculpatory evidence of the informant's criminal and the informant's background. Defendants' allegations continued. Through FOIA requests, they have obtained evidence that agencies other than the DEA were involved in the LSD investigation and have had records related to Skinner. That this evidence, the defendants assert, establishes the prosecution withheld exculpatory evidence at trial and that it then committed fraud in the 2255 proceedings by falsely denying the involvement of the other agencies. Further, that the claim of prosecutorial misconduct in the 2255 proceedings is a proper Rule 60B claim that should be addressed in the first instance by the district court. The defendants actually argued that the prosecutor committed fraud on the court. Next, the defendants applied for certificates of appealability to the 10th Circuit Appellate Court, appealing the district court's denial of their Section 2255 motion. While waiting on the appeal court's ruling, defendants filed 2 Rule 60B motions in the district court to set aside the district court's judgment in the Section 2255 proceedings. Of course, the 60B motion requests to the court to relieve a party or a party's representative from a final judgment or proceeding. For the purposes of this video, I want to address the second Rule 60B motion. In their second Rule 60B motion, the defendants argued that evidence of substantive, undisclosed FBI and IRS records newly obtained through defendants' FOIA request demonstrated that the prosecution had committed fraud because the FOIA documents showed that federal agencies other than the DEA were involved in investigating defendants' drug-related activities. They, the defendants, argued these agencies might have additional undisclosed evidence that could have been used at trial to impeach Skinner, the informant. The district court denied the motion. The defendants appealed. As to defendant's second 60B motion, the appellate court wrote, the claim of prosecutorial misconduct in the Section 2255 proceedings is a proper Rule 60B claim that should be addressed in the first instance by the district court. Now remember, it was not the appellate court's job to determine the merits of the defendant's claims. That's why the appellate court remanded the case for the district court to consider in the first instance defendant's claim that the prosecutor's false statement improperly prevented them from obtaining relevant discovery in the Section 2255 proceedings. In other words, the appellate court properly laid that at the feet of the district court to make that determination. I trust that this exercise encourages you to be assertive about filing FOIA claims, making requests, and obtaining information that is available and that you have a right to. When it comes to filing a Section 2255, don't be shy if the situation calls for it and your facts and circumstances justify it. Because some prosecutors will get away with what they can get away with, including withholding information that could be a matter of life and death to you, literally. Be vigilant, be kind, but be vigilant and assertive when you need to be, okay? All right, I'm Advocate Lucinda, and we will see you next time. Take care.